Hi, I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. And in this video, we are continuing our series on the E-2 investor visa by focusing on one of the most discussed E-2 visa questions, the investment requirement and what counts as a sufficient investment amount. Before we dive in, if you're interested in more information about the E-2 visa requirements, we've posted to our YouTube channel our full webinar on the E-2 visa. We also share a lot of free information about the E-2 visa and other visas on our blog. We'll link to both our blog and our YouTube channel below. Finally, please remember that no video or blog post can replace the value of working directly with an immigration lawyer who can navigate the specific nuances of your application. So, let's talk about the E-2 investment requirement. This requirement states that the E-2 investor must actually commit funds to the E-2 business. The funds must be at risk, which means that they must have actually been spent and not simply sitting in a bank account. This is a key point. Transferring $1 million, for example, into a business bank account does not satisfy the investment requirement. Instead, those funds need to actually be spent on the business. This is because there are two key things the officer is looking for in the investment amount. First, that the investor has spent enough money on the business to show that they're committed to it. And second, that the investor has purchased the variety of items that are needed for the business to be operational or nearly operational. Quick side note, we do have a separate video that discusses at length what to keep in mind regarding where the investment funds can come from, which is called the source of funds requirement. For now, just know that the source of the funds that are invested into the E-2 business can be any legal and legitimate source as long as any loan that's used is not secured by the E-2 business's assets. So if the funds need to actually have been spent, what should they be spent on? This is related to the real and operating requirement, which we also cover in a separate video. Please do check it out. In short, the officer will want to see that all of the items have been purchased that are necessary for the business to be operational once the visa is issued. Typical E-2 expenditures are inventory, equipment, a business website, office supplies, renting an office space, marketing, business entity setup, and any payroll or compensation paid to workers. Inventory and equipment does not need to be purchased in the United States and can be shipped to the US from another country. Some expenditures are not recommended and could raise concerns if they're included in the E-2 application. These include expenses for travel to and accommodations in the US to research potential business opportunities. Weak expenses also include those expenses that are reimbursed by a client or a customer, or expenses paid to a related party, such as a friend or family member of the investor. A vehicle can be a valid expense to include if it's clear that the business requires a vehicle, such as a home renovation company requiring a truck to transport workers and supplies. However, if a vehicle is not clearly needed for the business, it may be best not to include it among the business expenditures since it could raise questions. So, what is the best way to demonstrate the funds have been committed to the business? We recommend including in the application a spreadsheet that lists each expenditure, along with a page reference that points to where in the application the consular officer can find both an invoice or receipt showing proof that the item was purchased, and a bank statement showing that money was actually paid for the item from the investor's account. So let's turn to the all-important question of how much money needs to be invested into the E-2 business. Unfortunately, the government doesn't give us a set dollar amount. The amount needed depends on the type of business, where you apply, the consular officer, and the overall strength of the application. Regarding the type of business, the first question is how much money is usually needed to start this type of business. A law firm, for example, can often be started for less than $100,000, while an electric vehicle battery manufacturing company, for example, could require several $1 million to get started. The government will want to see that a large proportion of this amount has been funded and will apply what it calls the proportionality test in doing so. The proportionality test states that the less the business costs to start up or purchase, the more money that must be spent prior to filing the application. There's no bright line amount, but the U.S. Department of State suggests that spending 100% of the funds necessary to start a $100,000 business would be sufficient, while spending $10 million of a $100 million business could also be considered sufficient. If your business is a startup, you might consider including in your application additional evidence demonstrating that you've invested a substantial amount of funds into the E-2 business. This can include a letter from a certified public accountant, a CPA, stating that the amount invested is typical for starting the type of business in question. You might also include articles from trade publications in your field that explain what the typical investment amount to start the business in question is. Regarding where you apply, some consulates expect to see higher investment amounts than others. Also, USCIS is usually much more forgiving of a low investment amount than consulates tend to be. As a result, someone who is in the U.S. might consider a change of status through USCIS rather than applying for an E-2 visa at a consulate if they have a low investment amount. A qualified lawyer can help you understand where you might apply in order to maximize your chances of approval. Some applicants have invested all of the funds they believe are needed for the business, but the amount is still low enough to create a risk of denial. While each application is unique, we would generally consider an investment amount below about $100,000 to create some risk of denial, regardless of the type of business. Some types of businesses, such as law firms, simply do not require much money to start. What should the applicant do in these situations? Remember that the investment amount is not just about showing the officer that you have invested enough to make the business operational. The officer will also want to be convinced that you're committed to the business. Put yourself in the officer's position and imagine what you would expect to see if someone were trying to convince you that they are committed to building a business in the United States. Consider, for example, paying some expenses in advance, such as a year's worth of rent. This can bolster your investment amount and is acceptable since the funds used to pay for the advance rent are from the startup funds rather than operating income. Marketing is also an area where an applicant can usually spend more money while benefiting the business. But what if you have taken these steps and your investment amount is still low? To reduce the risk of denial, consider showing that your business is capable of generating revenue or employing workers, or both. If you have a low investment amount but are already generating revenue and employing workers, the consular officer will be less concerned that the low investment amount will result in the business being unable to employ workers, since the business is already doing so. Similarly, the E-2 investor could emphasize that, in spite of a low investment amount, the business is real and operating. The investor can do this by including in the application contracts with existing clients or letters from prospective clients about their intent to do business with the applicant and their business. This is an important point to keep in mind, especially when preparing a low investment or otherwise risky E-2 application. The consular officer will usually look at the application holistically, so emphasize where the application's strong if other areas are weak. A consular officer is much more likely to approve an application with a low investment amount if the business has already hired 2 U.S. workers, is generating revenue each month, and has clients, versus a business with a low investment amount that will only hire workers and generate revenue once the visa application is approved. But what if you're not starting a business, but are instead purchasing an existing business or starting a franchise? When buying a business, the fair market value of the business is usually sufficient to satisfy the investment requirement. The same is often true of franchises. Franchises are a good option for E-2 visas. If the investor has paid the funds that are typically required by the franchisor, then this tends to be sufficient for determining whether a substantial investment has been made into the business. One brief note: it's important to exercise caution if purchasing the business from a friend or family. The government will want to see that the investor paid the fair market value for the business. They'll scrutinize the application if it appears that funds are simply moving between family members or friends rather than actually being committed to the business. So if you're purchasing the business from family, take steps to show that you're paying the fair market value for the business, such as showing that it was advertised on the open market. One final topic we wanted to visit in this video is the use of an escrow agreement. Many E-2 investors are understandably concerned that they are committing a lot of money to an enterprise that could fail if the visa is denied. While the government's general rule is that the investment funds must be committed to the business, use of an escrow agreement is a rare exception. The government allows E-2 investor applicants to place the investment funds into an escrow account as long as the sole condition for the release of the funds is issuance of the E-2 visa. Therefore, if the visa is denied, the funds would go back to the E-2 investor, and if the visa is granted, the funds are released to complete the purchase of the E-2 business, franchise, or another significant asset for the E-2 business. Due to the nature of escrow agreements, they usually only make sense if the E-2 investor is purchasing a business or a franchise. For most startups, it's simply not feasible to place in an escrow account funds to pay an office lease, office equipment, or inventory. But for those E-2 investor applicants who are putting a lot of money on the line to purchase a business, a franchise, or pay for a significant business asset, an escrow agreement could give them peace of mind while not violating any of the E-2 application requirements. We hope this video about the E-2 visa's investment requirement was helpful. If it was, please click the like and subscribe buttons to stay updated on future videos about visa options and travel to the US. Thank you for watching.